Discrimination in the workplace is a serious issue. One of the key factors in determining whether discrimination has occurred is proving discriminatory intent. If you've been the victim of discrimination, how do you prove it? If you are an administrator, how to recognize discriminatory intent and prevent discrimination? In this video, we'll discuss how to establish discriminatory intent in the workplace. First, what is discriminatory intent? It means the intention or purpose to discriminate against an individual or group of individuals based on their protected characteristics, such as race, color, religion, sex, or national origin. Title VII of the Civil Rights Act of 1964 is a federal law that prohibits employment discrimination based on race, color, religion, sex, or national origin. These are the protected members of a class under Title VII, and employers are prohibited from making employment decisions based on those characteristics. Title VII of the Civil Rights Act of 1964 covers a wide range of employment decisions, including hiring, promotion, compensation, benefits, training, termination, and harassment. There has been debate about the concept of reverse discrimination, which refers to situations where members of a majority group, such as white people and men, are allegedly discriminated against in favor of members of a minority group, such as people of color and women. In the United States, the legal framework for addressing discrimination is based on the principle of equality as embodied in the 14th Amendment to the U.S. Constitution and federal civil rights laws such as Title VII of the Civil Rights Act of 1964. These laws prohibit discrimination on the basis of race, color, religion, sex, or national origin. They do not differentiate between discrimination against the members of a majority group or a minority group. Some may disagree, but this is a legislative issue, which is beyond the scope of our discussion on discrimination in employment. How to prove discriminatory intent? To do so, we must show that our employer or decision maker acted with the specific intent to discriminate. This can be done through direct evidence or indirect evidence. Let's first look at direct evidence. It means an explicit statement of discriminatory intent. In the workplace, administrators sometimes make outright discriminatory comments to justify their employment decisions. For example, you are not promoted because of your race or gender. As much as we'd like to believe that all administrators have better judgments, the reality is that some of them fall short. If that's the case, their statements can be used as direct evidence to explicitly indicate a discriminatory intent. What is indirect evidence? It means evidence of a pattern of discriminatory behavior. Even if there is no direct evidence of discriminatory intent, we may still be able to prove that the discrimination occurred by presenting evidence of a pattern of discriminatory behavior or by showing that employer's explanation for an employment decision was pretextual, meaning that the stated reason for doing something is not the real reason, and that there may be an ulterior motive behind it. For example, an administrator says, "This is a diversity hire." The statement may suggest that the decision to hire someone is based on their protected characteristic. For example, their race, ethnicity, gender, or other characteristic that promote diversity. Other statements could be problematic with discriminatory intent include, "We need to hire more people of color to meet our diversity goals, regardless of qualifications." This statement suggests that race is a factor in hiring decisions, and other qualifications may be overlooked in order to meet diversity goals. We don't want to hire another white man for this position. This statement suggests that candidates are being evaluated based on their race and gender rather than their qualifications and experience. We need to make sure that our team reflects the community we serve. While this statement may sound positive, it could be problematic if it suggests that certain candidates are being favored over others based on their race or ethnicity rather than their qualifications and experience. Those statements alone may not be enough to prove discriminatory intent, but it could be used as evidence of discriminatory intent when considered in the context of other evidence, including evidence that establishes a pattern or practice of discrimination, evidence of a history of discriminatory behavior by the person accused, or evidence that the person accused treated similarly situated individuals differently based on protected characteristics such as race, gender, or national origin. The employer has the discretion to choose among equally qualified candidates as long as the decision is not based on the protected characteristics. To prove discriminatory intent, we can present indirect evidence to establish that, first, other job candidates are better qualified for the job than the final candidates. Second, race or gender is a decisive factor in the hiring process. And third, the hiring process deviating for certain candidates, such as failing to follow standard hiring procedures or criteria. For example, your favorite candidate submitted the job application one day after the deadline, or you require certain candidates to meet higher qualifications than other candidates, or you ask illegal or irrelevant questions during the interview process, such as asking a candidate's age, race, religion, marital status, disabilities, and sexual orientation. That information may be voluntarily disclosed by the candidates, but you, as an employer, should not ask those questions. Also, you should avoid using that information to make hiring decisions or to discriminate against the candidate. Your focus should be on evaluating candidates based on job-related criteria, such as qualifications, skills, and experience. The legal principle of hiring decisions in the United States is generally based on the principle of merit, which means that employers should make hiring decisions based on an individual's qualifications, skills, and experience, rather than their protected characteristics, such as race, gender, religion, or national origin. This principle is embodied in federal and state employment laws, including Title VII of the Civil Rights Act of 1964, which prohibits discrimination on the basis of protected characteristics in all aspects of employment, including hiring. In practice, the principle of merit means that employers should use objective, job-related criteria when evaluating candidates for a position, such as education, experience, skills, and job performance. Employers should also avoid making assumptions or stereotypes about candidates based on their protected characteristics. While the principle of merit is a cornerstone of hiring decisions, there may be situations where affirmative action programs are implemented to promote diversity and address past discrimination. These programs must be narrowly tailored to achieve a compelling interest. The topic of affirmative action programs has been a source of debate and is currently reviewed by the U.S. Supreme Court amidst legal challenges. There is a debate about whether the principle of merit is inherently racist. Some argue that The focus on objective qualifications and experience can perpetuate systemic biases and limit opportunities for historically marginalized groups. Others argue that the principle of merit is an important standard for ensuring a fair and objective hiring process. As the saying goes, you can't address injustice by injustice. As an employer or hiring manager, it is important to be aware of these debates and to take steps to ensure that your hiring process is fair and inclusive. When making hiring decisions, it is important to focus on objective qualifications, skills, and experience that are directly relevant to the position.